Thank you for joining us for this Form I-956F overview. I will go through the presentation today, reviewing the information on the slides and providing some additional information. Let's start with some of the preliminary general matters that pertain to the Form I-956F. As you are all aware, the Form I-956F is a USCIS form that was newly created following the enactment of the EB-5 Reform and Integrity Act of 2022, the RIA, and was first published on June 1st, 2022. The goal today is to provide guidance regarding this form. Please note that throughout the presentation, we may say form instead of I-956F. When we say form, we refer to Form I-956F. If any other form is mentioned, the form number and name will be provided. It is recommended that you have a copy of the Form I-956F and I-956F instructions available to reference during this presentation. The information shared in this presentation is intended solely for the purposes of illustration and does not create or supersede agency policy with respect to the I-956F form instructions, or applicable statutes. Please consult these and other USCIS sources for additional information. The Form I-956F is the application for approval of an investment in a commercial enterprise. A designated regional center uses this form to request approval of each particular investment offering through an associated new commercial enterprise under Immigration and Nationality Act, INA, Section 203(b)(5)(f). The I-956F also is used to request an amendment to a previously approved I-956F. A regional center that has not yet received approval to be designated to participate in the Regional Center Program may not file Form I-956F. Before July 2021, Regional Center applicants could file Form I-924, Application for Regional Center Designation under the Immigrant Investor Program, for both initial Regional Center designations or to seek deference for determinations related to an associated investment project through an exemplar I-526 petition based on the investment project. In contrast to the previous Form I-924, the new Form I-956F does not allow a regional center to request initial designation. Rather, regional centers must use Form I-956, Application for Regional Center Designation, to request initial designation. USCIS provided an overview of the I-956 in a separate presentation, also accessible on our website. The RIA now requires that regional centers file an application for approval of each particular offering in a capital investment project, Form I-956F, before investor petitioners may file their Form I-526E petition in relation to the capital investment project. Investors may file their petitions once the Form I-956F has been properly filed. They do not have to wait until the form has been approved. The investor petitions may incorporate the project documents and evidence included in the associated Form I-956F by reference. And, except in certain circumstances, the approval of a Form I-956F is binding for purposes of adjudication of associated petitions for classification and removal of conditions. Because the new requirements under the RIA substantially differ from the previous optional process to seek deference for an exemplar project using Form I-924, USCIS created the Form I-956F to better facilitate the submission and approval of particular offerings in capital investment projects under INA 203(b)(5)(f). The form instructions clarify that legible photocopies should be submitted. The instructions also state that if the regional center submits original documents that are not required and have not been requested by USCIS, those original documents may be destroyed upon receipt. You may notice that the new instructions do not specifically require the regional center to submit any original documents along with the form. Therefore, in the context of the I-956F, do not send original documents unless specifically requested by USCIS. If USCIS specifically requires original documents, they will be returned to you after the adjudication process is complete. The information USCIS collects on the form is required by the RIA. USCIS will use the information provided to determine the eligibility of an application for approval of an investment in a commercial enterprise submitted by a designated regional center. USCIS may conduct standard background checks with law enforcement, which may uncover derogatory information that may result in a denial of the application. Now let's discuss the different parts of the form itself. Part 1 of the form requires applicants to select the type of application being submitted. If it is an amendment, regional centers should provide the original I-956F receipt number and NCE ID if applicable, as provided on the receipt notice received at the time of filing. USCIS will use these numbers to bundle the amendment with the original I-956F project and related filings. The form specifically asks for the legal name of the regional center entity as written on the entity's certificate of organization or certificate of incorporation. The Regional Center Identification Number, or RCID, is a unique 10-digit number that corresponds to the original receipt number for the regional center's initial I-956 application. The RCID is the same as the receipt number, just switching the INF prefix for the RC. Check your approval notices and look out for correspondence in the future to see if you have been assigned a new RCID. The regional center must provide the complete and accurate mailing address where it can receive correspondence from USCIS. If the regional center's physical address is the same as the mailing address, select the box indicating so. If the physical address is different, the regional center must provide the mailing address in this Part 2 and the physical address in Part 14 additional information. The form specifically asks for the legal name of the new commercial enterprise as written on the entity's certificate of organization or certificate of incorporation. The form also asks for any other name used or doing business as names. This information highlights any potential difference between the name of the NCE we'll be doing business as and the legal name of the underlying entity. If the NCE is comprised of a holding company and its wholly owned subsidiaries, the regional center must list each wholly owned subsidiary along with its date and jurisdiction of formation. The applicant should select the appropriate organizational structure and provide the date the NCE was established. The organizational structure should match the formation documents of the entity. The applicant should provide the state in which the NCE was established and all other states where the NCE is authorized to operate. The form also asks for the Federal Employee Identification Number for the NCE. The NCE must provide the complete and accurate mailing address where it can receive correspondence from USCIS. If the NCE's physical address is the same as the mailing address, select the box indicating so. If the physical address is different, the NCE must provide the mailing address in this Part 2 and the physical address in Part 14 additional information. The NCE should provide any other ways they can be contacted. Similar to regional centers, some of the NCEs may have an email address and a website for their specific investment project. The I-956F requires the address and census tract where the NCE is principally doing business, which, for purposes of the new Form I-956F requirements, means the project site address and census tracts. This is the physical address where the job creation is expected to occur. We are not looking for a P.O. Box address or the address provided on the NCE's Certificate of Organization or Incorporation. If the actual project location does not have an address, regional centers should indicate as such in the additional information section, but provide the project's approximate address or closest intersection or cross streets. When adding the census tract of the project location, please enter the 11-digit FIPS code, 2-digit state code, 3-digit county code, and 6-digit tract code format that uniquely identifies the project location in census tract. Next, the regional center must select the type of NCE that was established. If the NCE is a troubled business, an explanation should be provided in Part 14, Additional Information, together with relevant evidence as to how the NCE qualifies as a troubled business. Part 4 requires the same information about the job-creating entity as the information provided for the NCE in Part 3. This includes the job-creating entities, also known as JCEs, legal name, any doing business as, organizational structure, and date and state of the establishment, and other states or territories where the JCE is allowed to conduct business. If the JCE has a Federal Employer Identification Number, or EIN, you must provide this number in Item 8. The regional center must also provide the complete and accurate mailing address and other contact information for the JCE, if any. If the JCE's physical address is the same as the mailing address, select the box indicating so. If the physical address is different, the regional center must provide the mailing address for the JCE in this Part 2 and the physical address in Part 14, Additional Information. Finally, the regional center must indicate whether the JCE is an affiliated JCE. A JCE is an affiliated JCE if it is controlled, managed, or owned by any of the people involved with the regional center or NCE under Section INA, Section 203B5H5. A regional center must provide a comprehensive business plan for a specific capital investment project, as well as credible economic analysis regarding estimated job creation that is based upon economically and statistically valid and transparent methodologies. Regional centers should select the type of investment project being submitted. Regional centers should select all types that apply to their project. Investments in certain projects may qualify for the lower investment amount, which is now $800,000, and may also provide eligibility for one of the reserved visa categories established by the RIA. First, investment in a project located in a rural area qualifies for the lower investment amount and eligibility for one of the 20% of the EB-5 visas reserved for this type of investment. A rural area is defined as an area not within a metropolitan statistical area, MSA, or within a city or town with more than 20,000. Next, investment in a project located in a high unemployment area also qualifies for the lower investment amount and eligibility for one of the 10% of EB-5 visas reserved for this type of investment. A high unemployment area is defined as an area designated as such by the Secretary of the Department of Homeland Security or their designee. To qualify for this designation, the RIA limits the area to the project census tract plus any contiguous and adjacent tracts, where the weighted average of the unemployment rate for the tracts is not less than 150% of the national average unemployment rate. In addition to the project tract listed in Part 3 of this form, regional centers should list any contiguous and adjacent census tracts using FIPS codes they are requesting to include in the high unemployment area and the unemployment data for those tracts. In addition, regional centers should use the same data source when comparing the high unemployment area's unemployment rate to the national unemployment rate. For example, if a regional center used data from the U.S. Census Bureau's American Community Survey, or ACS, to determine the unemployment rate for the requested area, they should also generally rely on ACS data to determine the national unemployment rate to which the area identified is being compared. Regional centers should indicate the specific source of the data, either ACS or Bureau of Labor Statistics, and timeframe used in the unemployment rate calculations. A significant change made by the RIA relates to who can designate a high unemployment area. Under the pre-RIA framework, states were permitted to designate particular geographic or political subdivisions as high unemployment areas. However, the RIA explicitly limited the authority to designate high unemployment areas to the Secretary of Homeland Security or their designee within DHS. In addition, the RIA also limited the area that can be designated as a high unemployment area to the project census tract together with any contiguous and adjacent census tracts. Census tracts that are not adjacent to the project tract may no longer be included in a high unemployment area. Together, both rural and high unemployment areas are referred to as targeted employment areas. Investment in an infrastructure project also qualifies for the lower investment amount and eligibility for one of the 2% of EB-5 visas reserved for this type of investment. An infrastructure project may be designated by the Secretary of Homeland Security or permissible designee and is defined as a project administered by a governmental entity such as a federal, state, or local agency or authority. That is the JCE contracting with an RC or NCE to receive capital investment under the Regional Center Program as financing for maintaining, improving, or constructing a public works project. Finally, there are two types of projects that generally require investment of the standard amount of $1,050,000. This includes projects in a high employment area, which refers to an area that is not a TEA and has an unemployment rate significantly below the national average unemployment rate. The statute does not define exactly what unemployment rate would be considered significantly below the national average unemployment rate, but self-reporting on the Form I-956F may help DHS collect data for future use in this area. Note that while the Secretary may specify a higher amount for investment in a high employment area, that has not yet been done, and the investment amount required in a high employment area is still generally the standard amount, unless it is an infrastructure project in a high employment area, in which case the reduced investment amount would apply. Lastly, standard projects that are not of any of the specified types, such as an infrastructure project, a targeted employment area project, or a high employment area project, require investment of the standard amount of $1,050,000 and do not provide eligibility for one of the reserved visa categories. On the form, these projects are referred to as non-TEA, non-infrastructure, non-high employment. Beginning with Part 5, Item 6, the I-956F requires detailed information about the project being submitted. These details include total estimated cost of the project, the expected number of EB-5 investors, the amount of project capital to be financed by EB-5 capital, and the estimated number of jobs to be created. The I-956F also requires Regional Center to indicate the nature of activity of the project. For example, is the project to develop an assisted living facility? Is it to develop an apartment building or a mixed-use residential and commercial building? Depending on the nature of the project, regional centers should find the primary NAICS industry codes that most closely relate to the project. Finally, regional centers should provide a breakdown of the estimated job creation by NAICS industries. This is typically taken from the regional center's economic impact analysis. Regional centers should ensure that the information provided for these items are consistent with the supporting evidence submitted with the I-956F. Any inconsistencies between what is provided on the form and any other evidence submitted may result in a request for evidence. In addition to submitting a comprehensive business plan and a credible economic analysis, regional centers must also include any documents filed with the Securities and Exchange Commission under the Securities Act of 1933 or with the securities regulator of any state as required by law. In their supporting evidence, regional centers must include all investment and offering documents, including but not limited to subscription, partnership, and operating agreements, private placement memoranda, term sheets, and marketing materials used in connection with the offering. The regional center's offering documents must disclose certain information, including all material investment risks associated with the NCE and the JCE, and any conflicts of interest that currently exist between these entities or individuals responsible for such entities. The regional center must also disclose any pending material litigation or bankruptcy, or material adverse judgments or bankruptcy orders issued against these entities or individuals during the most recent 10-year period in the United States or in another country. Finally, the regional center must disclose all fees, ongoing interest, or compensation paid by the regional center, the NCE, or any issuer of securities to any agents, finders, or broker-dealers involved in the offering of securities to prospective EB-5 investors. Regional centers must also describe the services being provided to warrant such fees and compensation and name and contact information for each such person. It is important that the regional center properly disclose and address all the questions mentioned in this part of the form. Regional centers should clearly describe the type of documentation being submitted, providing these disclosures and where it can be found in the file by providing the exhibit number and the name or title of the document. Regional centers must describe the policies and procedures in place that are reasonably designed to cause the regional center and any issuer of securities to be offered to prospective EB-5 investors, such as the new commercial enterprise, to comply with securities laws of the United States and the applicable states in which the securities will be offered. Regional centers may submit documentation describing these policies and select the appropriate box indicating they are doing so. If selecting this box, regional centers should clearly describe the type of documentation being submitted and where it can be found in the file by providing the exhibit number and the name or title of the document. If no documentation describing these policies is being submitted, regional centers must describe these policies in the text provided on the Form I-956F using Part 12, additional information if more space is necessary. The form requires the signature of a qualified certifier. A qualified certifier is a person in a position of substantive authority for the management or operations of an entity, such as a principal executive officer or a principal financial officer, with knowledge of the entity's policies and procedures related to compliance with applicable requirements. The I-956F also requires the qualified certifier's identifying information and contact information in case USCIS needs to contact the individual. Part 8 requires two different certifications. Both certifications relate to complying with securities laws of the United States and the applicable states in which the securities will be offered. The first is a certification by the regional center. The qualified certifier certifies that to the best of their knowledge, after due diligence investigation, the regional center and any parties associated with the regional center are in compliance with the securities laws of the United States and the applicable states in which the securities will be offered in connection with the capital investment project described in the application. The second certification is the certification by the issuer of the securities. The qualified certifier must certify that, to the best of their knowledge, after due diligence investigation, the agents and employees of the issuer of securities named on the I-956F and any parties associated with such issuer of securities are in compliance with these securities laws. Note that the same person may serve as the qualified certifier for both required certifications. The I-956F requires regional centers to identify all persons, both individuals and organizations, involved with the NCE and affiliated JCE. Please refer to INA 203B5H5 or the I-956H form and the instructions for an explanation about which persons are considered to be involved with the NCE or affiliated JCE. Regional centers must list directly on the I-956F the full names of all persons under the appropriate role in the NCE or affiliated JCE. For example, are they an owner, an executive, a member of the board of directors? If the same person is involved in multiple roles in the NCE or affiliated JCE, their name must be listed under each appropriate role. For example, if someone is the owner of the NCE and also its chief executive officer, that individual's form name should be listed twice, once under item 2 and again under item 4. Even if an individual is listed twice under different roles on the I-956F, this individual will only submit one I-956H. For persons involved with the NCE or affiliated JCE, indirectly through their position or other interest in a legal entity, the organizational structure of their involvement should be described as appropriate. For example, if the regional center is owned and managed by a separate LLC, and an individual is the owner and manager of that separate LLC, the LLC's ownership of the regional center and the individual's ownership and position as manager of the LLC should be described in the appropriate field on the form. If additional space is necessary, Part 14 additional information can be used. All persons, which includes individuals and organizations involved with the NCE or affiliated JCE identified on the Form 956F, must submit a Form I-956H. Finally, provide the total number of unique I-956Hs for all persons, both individuals and organizations, that are being submitted along with the I-956F. Regional centers should gather all I-956Hs from all persons involved with the NCE or affiliated JCE before filing the I-956F and submit the I-956F and the I-956H supplements at the same time. This helps USCIS bundle the I-956F with the associated I-956Hs and will help facilitate the adjudication process. The RIA added new requirements mandating that NCEs and affiliated JCEs set up a separate account to manage capital investment received from EB5 investors for the project. If a separate account has already been set up by the time the regional center files the I-956F, regional centers should provide the bank name and account number for each separate account set up. If a separate account has already been set up, regional centers should also indicate whether they have retained a fund administrator, such as a certified public accountant, attorney, or broker-dealer or investment advisor, registered with the Securities and Exchange Commission to manage the funds. If a fund administrator has been retained, regional centers should provide the fund administrator's name and organization, as well as any relevant certification, bar, and/or registration number. Finally, regional centers should indicate if a registered investment advisor or broker-dealer controls the NCE and/or affiliated JCE. If so, the regional center should provide identifying information along with title and registration number for the registered investment advisor or broker-dealer. Like the prior Form I-924, the Form I-956F requires the signature of an authorized individual who has been granted the authority to file the form on behalf of the regional center. The I-956F requires the authorized individual's identifying information in Part 11. The authorized individual may or may not be the same individual acting as a qualifying certifier mentioned earlier. If the individual is the same, the individual must still provide their identifying information and contact information in both sections. If the authorized individual does not understand English and had an interpreter assist in the reading of questions and filling out of the form, they must select the appropriate box and provide the interpreter's name. The interpreter must then complete the Part 12 of the form. If the authorized individual is not filling out the form themselves, then the authorized individual must select the appropriate box and provide the name of the preparer who prepared the application. The preparer may be an attorney for the regional center. The preparer must then complete Part 13 of the form. If the same person was the interpreter and preparer, that person should complete both Parts 12 and 13. Please note that even if a preparer prepared the form, it is still the authorized individual's responsibility to declare, under penalty of perjury, that all information contained in the form is complete, true, and correct, and that they are authorized to file on behalf of the organization. The authorized individual must also declare, among other things, that they recognize USCIS's authority to conduct audits using publicly available information and recognize that USCIS may verify information through any means determined appropriate by USCIS, including but not limited to on-site visits. If the authorized individual used an interpreter to read or fill out any portion of the I-956F, the interpreter must provide information including name, mailing address, and any other contact information where the interpreter may be contacted. The interpreter must also provide the business or organization the interpreter works for, if any. The interpreter must certify that they are fluent in English, that the interpreter read all questions to the authorized individual, and that the authorized individual understood all questions and instructions on the I-956F and verified accuracy of every answer. As stated above, if an individual other than the authorized individual mentioned earlier prepared and completed the I-956F on behalf of the Regional Center, the preparer must complete Part 13, including identifying and contact information. This information also includes the preparer's name, mailing address, and any other contact information. The preparer must also provide the business organization the preparer works for, if any. The preparer must indicate whether they are an attorney or accredited representative, certify that they prepared the form at the request of the authorized individual, and certify that the authorized individual reviewed the form and that all the information provided on the application is complete, true, and correct. As you can see, the I-956F requires individuals' signatures. Each application must be properly signed and filed. Please note that it is not acceptable to use a stamped signature or typewritten name in place of the certifier, authorized individuals, interpreters, or preparer's signature. This includes electronic signatures. USCIS will not accept signatures created by AutoPens or similar devices. Any unsigned applications will be rejected. If we accept the application but then determine the signature is deficient, we will deny the application. However, USCIS will consider a photocopied, faxed, or scanned copy of the original handwritten signature valid for filing purposes. The photocopy, fax, or scan must be of the original document containing the handwritten ink signature. Like the previous I-924 and many other USCIS forms, the Form I-956F features this robust and flexible section for applicants to provide additional information. As noted earlier, many regional centers will need to use this part to provide additional details for various parts of the form. Make sure that additional information you include in Part 14 is accurate and consistent with the other data on the form, as well as the supporting evidence submitted with the form. If more space is needed, regional centers can make use of as many copies of Part 14 to provide additional information and file with their application. Regional centers should provide their regional center name and regional center identification at the top of each Part 14 they submit. You must mail the completed application, supporting documentation, and the correct filing fee to the appropriate address. Applicants should check the USCIS website for the most current mailing address. As stated above, regional centers should gather all required I-956Hs and submit at the same time as the I-956F. This will help USCIS bundle all the files together and will help expedite the adjudication process. Please note, if you send your Form I-956F and I-956Hs to IPO in Washington, D.C., we will reject it. Each person, which includes individuals and organizations involved with the NCE and affiliated JCE, must complete and submit Form I-956H, bona fides of persons involved with the Regional Center Program. A person involved with a JCE that is not an affiliated JCE may, at DHS Secretary's discretion, be required to submit a Form I-956H. Please review the Form I-956H instructions for more information. This concludes our presentation. Thank you for your time.